speaker is Hanna Lerner. Dr. Lerner is a senior lecturer in the political science department here at Aviv University. Her research focuses on comparative constitutional writing, particularly in societies divided over the visions of their state, religion, and politics. She writes on democratic theory, on global justice, and international labor rights. Dr. Lerner is the author of Making Constitutions in Deeply Divided Society with CUP 2011, and the co-editor of Global Justice and International Labor Rights with Yossi Dahan and Faina Milna Sivan, also with CUP, and the Constitution Writing, Religion and Democracy with Azit Libali in CUP 2017. So in 2014, she convened a research group on constitutionalism, religion, and human rights at the Center of Interdisciplinary Research in Germany, and she also held visiting fellowships in Princeton, in Metz, and in Amherst. So it is really a wonderful pleasure to have Hanna Lerner here with us.
Thank you very much. Is it okay if I sit or I can stand? That looks better. Okay. I need to look my, yeah, it's a matter of, just a small, no, it's a small room, so okay. Now I can, thank you. So thank you for the invitation to participate in the conference. In many ways, our papers are sort of related. Indeed, high hopes have been placed in recent decades, actually, in the ability of courts to promote the rule of law, to protect individual rights, to enforce the separation of powers, to facilitate accountability among political players, and to resolve ideational and ideological conflicts. Such hopes have led drafters of new constitutions in democratic and in democratizing countries to adopt systems of constitutional judicial review by establishing constitutional courts with exclusive jurisdiction over judicial review. For example, just most recently, in the post-Arab uprisings in the Middle East, several constitutions, but especially Tunisia, in Tunisia, drafters strengthened the role of the courts in interpreting and enforcing the constitution. Yet, in many of these cases, the drafters of those constitutions intentionally also left some foundational issues, for example, concerning religion and state relations or definitions of national identity. They left these issues undecided. And the constitutional courts are now left to serve as a central vehicle of conflict resolution in ideational conflicts and tensions, and are expected to advance clear-cut decisions on the state fundamental norms and values, even if those have not been clearly decided by the Constitution. So this is the problem I'd like to discuss today in the presentation, which is based on a chapter I've written for an edited volume on comparative judicial review, and in a way it looks at this problem of it looks at judicial review from the perspective of one can term it a political continuity of ideational tensions or ideational conflicts that start in the pre-drafting stage, continue through the drafting of the Constitution, and move on to the post-drafting interpretation or implementation era. The purpose of the chapter is to analyze, the risks and opportunities involved in constitutional drafting and constitutional interpretation in deeply divided societies. And I'll say a few words about this term too. The main argument is that under conditions of foundational disagreements over the basic norms and values that should underpin the state, judicial intervention in controversial issues may both generate a harsh political backlash, and weaken the court's legitimacy as a political neutral defender of democratic procedures. So eventually, such developments may undermine the main purpose for which strong constitutional courts were designed to achieve in the first place, strengthening the rule of law. So not very optimistic, and in a way, sort of, Yaniv talked about a specific kind of procedure through which this is happening. So in the rest of the presentation, I'll say it will include three parts. I'll first say a few words about what I mean by divided societies or deeply divided societies, and then we'll discuss the challenges of drafting constitutions in such societies under such conditions, and present one solution that is often adopted by democratic drafters. That is the permissive or the incrementalist constitutional approach. And then I'll talk briefly about three potential risks, consequences of this approach. And I hope I'll have time to do all that in the remaining, 17 or 16 minutes I've left. Okay. So what are divided societies? Obviously, it's a vague term, and in a way, all constitutions can be regarded as divided to a certain degree, either culturally or ideologically. There's no society, there's no country around the world that is completely homogeneous or lacks any political disagreements. Yet a growing number of scholars think that there's a difference between levels of divisions or intensity of the tensions, political disagreements, and between the ways that these tensions or conflicts affect constitution making and constitutional interpretation. So the distinction here is between societies that are heterogeneous or multicultural, but still share a basic consensus around the idea of basically political liberalism. Society, countries like the United States, Canada, most of Western Europe, and divided societies that are where such consensus does not exist, and where identity conflicts, especially around religious, national, or linguistic identities, are much more intense and enduring. And I should just open to say, I think when this paper was written, this division between those two types of divided societies was much clearer than sort of the West and the and the non-Western world was much clearer than maybe recent years. We're now seeing kind of a convergence around more deeply divided societies, even in Western countries. But still, I think this is a question that we still need to ask ourselves: to what extent really this kind of distinction between types of political tensions and divided societies can be made. So is the U.S. and Belgium are the same as Sri Lanka, Egypt, Tunisia? I think we need to still think about these issues. Anyway, by the term deeply divided societies, what I mean is societies where frictions extend beyond the kind of tensions that can be bridged by what John Rawls calls overlapping consensus. And they're difficult to resolve by mechanisms of resource or power allocation, because usually they involve competing perceptions regarding the fundamental norms and values that should guide state policies for the entire population. So Albert Hirschman terms these types of conflicts non-divisible as opposed to divisible conflicts. And they're characterized by the unwillingness of the parties to compromise. These conflicts may occur between different identity groups, but they can also cut across such intergroup tensions, and usually they characterize sort of intra-religious or intra-ethnic tensions. For example, between those who hold a more fundamental or conservative worldview and those that advocate for a more sort of liberal or secular values. And they can be, both sides can be members of the same religion. For example, Muslims in Tunisia, Egypt, or Indonesia, Jews in Israel, Hindus in India, Buddhists in Sri Lanka. So the division is among them and not necessarily between them and another religious or ethnic group. I should just say that indeed the universe of divided societies that I am interested in is, or the focus of the paper, does not include what is known, at least in the comparative politics literature, as failed states, where the conflict is not only on the fundamental issues, but also on the very basic institutional structure of the state. So we're not talking here about places like Libya, Yemen, Afghanistan, or Congo. The focus here is on functioning states. When such deeply divided societies come to the task of drafting a constitution, the lack of shared norms becomes a central obstacle. And the act of writing a constitution brings non-divisible conflicts into the high-stakes arena of entrenched law and places additional pressure on the political system. In cases of intense internal disagreements, constitutional debates risk turning into a political battleground, emphasizing the differences between the various positions rather than bridging them. So instead of being a vehicle for compromise, constitutional debates can become a source of escalating tensions. And in the worst case scenario, the intensification of the ideational conflict may lead to outbreak of violence, civil war, even partition of the territory, and we have some historical examples. For example, in India, the failure of the pre-partition constituent assembly. So the constitution drafting process began 7 months before independence, and when the constitution was designed for the greater India, which was supposed to include Pakistan and what is now Pakistan and Bangladesh, but the project failed and the territory was divided. Another example for a failed attempt to draft an inclusive and democratic constitution is, of course, more recently Iraq in 2005. The literature on institutional design usually focuses on constitutional solutions for promoting democracy under such conditions of internal identity conflict. In terms of these solutions include, for example, mechanisms of some form of federalism or other mechanisms for increasing integration or accommodation of particular cultures or identity groups, such as power sharing and other consociational mechanisms, or practices of minority groups. But these solutions usually work well under conditions of either geographical separation or when the groups are under conditions of inter-ethnic or interlinguistic conflicts. These tools are less appropriate when the conflict is between competing perspective on the character of the state and when the competing camps wish to imprint their conflicting visions on state symbols or on national emblems. So most of these proposals, and there's a huge literature on that, especially in comparative politics and political science, most of these proposals for institutional design rest on sort of a revolutionary perception of constitution making rooted in a liberal constitutionalist worldview. According to this approach, the moment of constitution making is generally perceived in terms of new beginning, a foundational moment of radical reform, and the drafting of this new constitution is expected not only to establish the institution of the state, but also to sort of facilitate redefinition of ideational issues such as national identity again or religion of the state. So an Akermanian perception of constitution making. However, if we look sort of a brief historical observation on the way deeply divided societies draft their constitution, reveals that constitutional drafters often prefer to refrain from making clear-cut choices in controversial foundational issues and rather tend to balance the democratic aspirations with deep disagreements over the vision of the state by adopting what can be called permissive constitutional arrangements, permissive constitutional approach or incrementalist constitutional approach. And it's an approach, I term it as an approach rather than a model because it may be manifested through various constitutional strategies. These include deferring controversial decisions, using ambiguous and vague language, incorporating conflicting provisions in the formal constitution, or including non-justiciable sections in the constitution. So constitutional drafters often adopt permissive constitutional arrangements in order to give the political system greater flexibility for future decisions about these controversial questions, particularly, as I mentioned, around issues of religion, national or linguistic identity. Such strategies allow constituent assemblies to circumvent political potential explosive conflicts by basically shifting the burden of resolving or at least even further discussing these contentious debates to the new political institutions that are created by the Constitution. And I use the term constitutional flexibility here, but it does not refer to amendment rules or to the level of entrenchment or rigidity of the written constitutional provisions. Rather, flexibility here refers to the degree to which the formal constitution limits the range of political possibilities to be decided by ordinary legislation. So, in other words, permissive constitutional formulations in the areas of religion, linguistic, or national identity transform those controversial choices from the level of a entrenched constitution to the level of ordinary legislation. So basically pass them hot potatoes to the political system. And such strategies have been documented by there are actually a number of scholars who refer to them as decisions not to decide, gag rules, or incomplete theorized agreements. And in my paper, I mainly focused on permissive arrangements that have been adopted by constitutional drafters in order to address various types of identity conflicts. So, for example, the Indian Constituent Assembly chose to defer choices about the contentious questions of the country's national language to future legislations. They basically included in the former constitution a provision stating that in 15 years a committee will decide what would be the language, the national language of India. Similarly, after 3 years of controversies over the formulation of the Hindu Code, which was meant to regulate Hindu family code, the drafter decided to leave these controversial issues to further deliberation and decision by the parliament. So they completely took it out of the formal constitution. We can see ambiguous language with regard to religious or secular identity of the state intentionally used in the constitutions of Tunisia, for example, vague language with regard to women's rights, the 2012 Constitution of Egypt, in Sri Lanka, the Sri Lankan Constitution from 1972. So those constitutions use sort of vague language as a form of compromise between, again, competing religious and fundamentalist or liberal secular camps. And non-justiciable provisions were adopted in the constitutions of India, Sri Lanka, and Pakistan, and various other constitutions in order to separate, as a separate section, usually titled Directive Principles of State Policy. Again, addressing not only religious but also socioeconomic issues. So these sort of arrangements of avoidance and ambiguity in the Constitution are very useful, but they also carry several potential dangers. And I'll mention briefly three such risks that affect then the working of the court. So the first one, the first risk, one of the main risks of delegating those high-stakes issues to legislature is that these issues eventually may not be addressed at all. It's not always a bad thing. It can be there can be a positive outcome when the permissive strategies adopted by constitutional drafters lead to decisions that allow eventually for pluralistic policies. So for example, the decision to defer the formulation of national language in India and the parallel decision to recognize over 20 other languages led to a more pluralistic approach towards linguistic policies in India, and eventually took the linguistic conflicts almost off the political conflict. But when the conflict of that the framers are attempting to avoid has to do with religious issues, then the deferral of clear decisions jeopardize what is commonly viewed as a sort of constitution's main function, which is to protect liberal values and basic rights. And then usually the religious traditions that are defended in such cases are more patriarchal in nature, and accommodating them within the constitutional framework leads to infringement of women's fundamental rights and their legal personhood, etc. The second risk is somewhat related, and that is the risk of over-rigidity. So constitutional frameworks in deeply divided societies may believe that they can transfer decisions on contentious issues to the more flexible arena of ordinary politics, but it's not always the case. Ambiguous constitutional formulations often allow for the emergence of material constitutional arrangements, either unwritten or in the form of ordinary legislation, and they often appear to be rigid, and more rigid even, than formal constitutions would have been. So, for example, the prohibition on public transportation on Shabbat in Israel is an example, very difficult politically to change, although it's sort of almost an unwritten arrangement. The third potential risk more directly concerns the judiciary and its relationship with the political system, and if the legislature is unable to settle controversies around fundamental norms or ultimate goals of the state, it may lead to the growing involvement of the judiciary, especially the Supreme Court, which may result in a conflict between the two branches of government. So the prolonged public and political controversies over unresolved fundamental issues may overburden the court and increase the tensions between the legislature and the judiciary, which some view as a weakening feature of democratic order. The tension between legislature and judiciary, as two branches of government, is inherent to any democratic system. However, lack of constitutional clarity on contentious foundational issues can lead to confusion over which branch of government should take the lead in dealing with such issues. And this is particularly problematic if the Supreme Court and the Parliament hold opposing views regarding the foundational issues at stake. So the Supreme Court are generally expected to serve as a chief protector of individual rights. Parliament, by contrast, as representative bodies, and more responsive to particular demands of interest groups. And consequently, judiciary and the legislature may attempt to advance competing visions of the state. And the danger here is that this difference between worldviews will result in direct clash between the two institutions. And this sounds familiar to all Israelis. It's basically the story of the Constitutional Revolution and the counter-revolution and the backlash, the political backlash which we are now viewing. So I'll jump to the Just few concluding remarks. I wanted to say something else about India, but I'll just summarize. Even beyond considerations of interinstitutional relations, the judiciarization of politics in divided societies recently generated some skepticism concerning the limited ability of constitutional law and courts to mitigate intense ideational conflicts due to the inherent nature of the legal practice. Under conditions of deep social disagreements, this binary framework of legal language and the type of clear-cut decision-making offered by the court may entrench or even further polarize existing conflicts. Religion is an obvious example, but also other identitarian issues. The judicialization of disputes on fundamental issues, often perceived as a tool for moderating tensions, may lead to counterproductive dynamics, and it was documented, such dynamics was documented in various religiously divided societies such as Sri Lanka, India, Malaysia, and Pakistan, and there are really interesting, good books written about these developments. So Ben Chantal on Sri Lanka, Tamir Mustafa, just a few months ago, his book on Malaysia was published, exactly documented these sort of political backlashes to the judicialization of religious conflicts. So when societies are still grappling with deep ideational tensions, courts may, even unintentionally, advance the perpetuation rather than the mitigation of these social strifes. And sorry, I don't have a more optimistic, conclusion, but at least we should not be surprised when it's happening. It's not. I think it's a common phenomenon. It's not an Israeli, uniqueness.